user. Talk about most of what I do is
Hello?
migration to the experience.
Sorry.
Alright. I'll take it.
I'll see. Well, thank you for attending or logging in this evening. The title of the paper is not mine. It was suggested to me by Jackie, but it's inspired by a few cases that I've done recently which have concerned publications in languages other than English. The Greek one is a case which is currently before Justice Abraham in the Federal Court, where I'm acting for the Greek Orthodox Archbishop. But there are also a couple of other cases involving Korean parties and publications in the Korean language. And those are the ones that really got me thinking about this topic. In one of the Korean cases, my client was being sued for a series of publications in which he allegedly accused the plaintiff of fraud. And my solicitor called me up one day and explained to me that he'd spoken to his client and talked him through what the word fraud actually means in English. And the client's immediate reaction was, that isn't what I meant to say in Korean. Now, as defamation practitioners, we all know that whatever the poor defendant meant to say isn't relevant to the question of what it means in the proceedings. But this exchange did get me thinking about how we apply the general concepts of defamation law to material which was originally published in a foreign language. Because the concept of language is really central to defamation, and so much in a defamation case rides upon the way the parties to the case, that is the lawyers and the judge hearing the case, or the jury, construe the words that are used. That's easy enough when we're construing words which were originally written in our native language and which are addressed to people who come from the same ethnic and cultural background as us. But when the words are taken out of that context, when they were originally published in a different language to people who may not share our cultural or religious assumptions and attitudes, that can have a significant impact on the way we construe the meaning of words. Also, when material is published in a foreign language, it's a fair assumption that it's likely to be addressed to a particular community of people, such as the Korean community or the Greek community, or potentially a religious community, such as Muslim people, if matter is published in Arabic, for instance. And that gives rise to questions concerning the application of the common law qualified privilege defence, for instance. And one of the things I want to talk about tonight is a series of cases which have looked at that issue in the context of foreign language publications and publications to particular ethnic communities. And it may also affect the way we assess damages. But the starting point is meaning. Obviously, when something is written in a foreign language, it needs to be translated into English. But I think there is a tendency in the courts and in practice to think about the process of translation as something which is purely mechanical. We think about a translator's job as though it was merely cracking a code or producing a one-to-one equivalent in English of whatever the source text says. Anyone who has studied a foreign language knows that that is not the way translation works, and that there is considerably more complexity to the task. My colleagues in chambers know that I am an incorrigible francophile, and the point is illustrated by possibly the most famous sentence in French literature, Longtemps je me suis couché de bonne heure, which is the opening of In Search of Lost Time. It's usually translated as meaning, for a long time I used to go to bed early, But there are some editions in English which translate it as, for a long time, I have gone to bed early. According to a readers' poll conducted by Penguin, the preferred translation was, for absolutely bloody ages, it was lights out early. But what we can see in these different translations is there is a shifting in the point in time which is being referred to by the verb. In the usual translation, Proust is talking about something which exclusively happened in the past. For a long time I used to go to bed early, but now I don't. Whereas in the alternative translation, for a long time I have gone to bed early, he's talking about something he still does today. And in a book which is literally about finding lost time, this is a rather important point for how you understand the first sentence of the novel. The point is this: when you open up a dictionary for a foreign language and look up any particular word, you'll generally get a series of potential definitions. Some of those definitions may be merely shades or nuances of the same basic meaning, but other ones may reflect entirely different meanings based on particular historical or literary or poetic or colloquial usages of the word. The translator is extremely unlikely to find a single English word which captures all of the potential meanings of the source word. And so the act of rendering that French or Arabic or Hindi word into English involves confining the range of meanings which it might be capable of bearing. On the other hand, the process of translating may open up a whole different series of meanings in the opposite direction, because English words have the same potential for shade and nuance in different cultural or literary or colloquial usages. Now, as defamation practitioners, we know that when one is assessing defamatory meaning, there are two stages to the inquiry. The first is what range of meanings are the words capable of conveying? If in the process of translation you have read down or confined the range of meanings which the original Korean or Greek or Mandarin text may be capable of bearing, that may work an unfairness to a defendant who wishes to dispute the meaning pleaded by the plaintiff. There isn't really a good solution to this. It's a basic principle that evidence is not admissible on the question of defamatory meaning, but there is also a real problem in relation to trial management. It might be open, for instance, for a defendant to serve a competing translation of the defamatory matter, or to agree on a translation with the plaintiff, but to footnote particular words, particular significant words which may be capable of more nuanced meanings than what is ascribed to them by the plaintiff's translation. But at some point, the trial judge needs to come to a decision about the single meaning of the matter complained of, and the meaning which ought to be ascribed to it for the purpose of assessing liability. And it's difficult to see how a judge could do that without hearing possibly expert evidence from the translators about which of the possible meanings is the preferred or more likely meaning in the native language. That is clearly not desirable from a cost perspective and from the perspective of overburdening defamation proceedings with additional complexity when they already have plenty of that. But I think it's necessary for us as practitioners to bear the potential for that kind of unfairness and that kind of complexity in mind, and not to assume that the process of translation is purely mechanical. Now, aside from the question of what the words are capable of meaning, linguistic or cultural considerations could also affect one's assessment of whether they are defamatory. To give a trite example, as we all know, there's a certain word for part of the female anatomy which is considered to be highly offensive in many countries, but here it's a term of endearment. And one can potentially think of other words which may convey a particularly strong defamatory meaning in their native language, but translation doesn't quite capture the sting. This almost arose in a case called Matika and Goyan in 2007 in the Supreme Court. I'll explain why I say almost arose. The matters complained of in that case were a series of letters which were written, some of them were in Ukrainian and some of them were in English, and they were sent to members of the Ukrainian community. In some of those letters, the defendant referred to the plaintiff by a particular Ukrainian word, which was translated into English as witch. Now, witch is not a nice thing to call a person in English, but it's probably not at the level of being defamatory in this language. But there was an issue in the proceedings as to whether the defendant had acted maliciously in publishing these letters. And the plaintiff sought to put the malice case on the basis that the defendant's language was so intemperate and unreasonable that it conveyed an inference of malice. One of the questions which arose was whether, in deciding that issue, the court could take into account evidence from the plaintiffs about the fact that the Ukrainian word, which was translated as witch, carries particular connotations in Ukrainian which are more derogatory and offensive than the corresponding English word. Now, an objection was taken to that by the defendants in the case, and the trial judge, who was Justice James, didn't have to resolve the issue. That's why I say that the issue didn't really arise. But it has to be said, when one looks at the authorities as a whole, that the courts have generally been against the idea that the standards or attitudes of a particular part of the community are relevant to assessing whether something is defamatory. That has generally arisen in the context of cases where the matter is published about a person's professional reputation, and the question might be raised as to how that defamatory publication would be perceived by members of the plaintiff's profession. But it entails some real difficulties when that type of reasoning is extended to particular linguistic or ethnic or cultural communities. The general principle was stated by Justice Brennan in Reader's Digest and Lamb, and that is that the ordinary reasonable reader, who is the standard by which these matters are assessed, is taken to share a moral or social standard by which to judge the defamatory character of an imputation, and that is a standard common to society generally. And he went on to say that the defamatory nature of an imputation is ascertained by reference to general community standards, not by reference to sectional attitudes. Now, the notion of something being a sectional attitude, an attitude of only a section of the community, is really difficult when it is applied to a publication in a foreign language to people who speak that language, because they are the only community who receive that publication. As a matter of law, defamatory matter isn't published if it's published in a language other than English, unless somebody who speaks the relevant language read it or heard it. So, if we're talking about something published in a foreign language newspaper or after hours on SBS, that really is the entire community of recipients of the matter complained of. It's not merely, and their standards are not merely sectional standards. It's also problematic because there have been cases where courts have been prepared to consider the attitudes of particular sections of the community on highly contentious social issues. So, for example, and this is apparently now controversial again, in Hepburn and TCN Channel 9, there was a question as to whether it was defamatory to say that somebody lawfully performs abortions. And the court was prepared to consider the fact that a certain group of people in society do consider that to be destructive of a person's reputation, whether or not they're doing so lawfully. So why not the standards of a particular ethnic community or a particular linguistic community? The High Court referred to this issue in Radio 2UE in Chesterton, but only to say that it needed further consideration, and the very concept of community needed further consideration in an appropriate case. But in saying that, they cited an English decision, which I've put in paragraph 17 of the paper, that is Arab News Network and Al-Qasem, where three members of the English Court of Appeal said in obiter that they had real difficulty with the idea that the standards of a particular ethnic community were relevant to assessing the defamatory capacity of words. I think that difficulty primarily arises from the evidentiary problem that I referred to earlier. It's well established that one cannot tender evidence on the question of what words mean, whether they are defamatory. And I would suggest that the safer approach for practitioners in this field is to give serious consideration to how they plead the defamatory imputation, and most likely to plead it as a true innuendo. Now, the second issue that I raised at the outset was how the defence of common law qualified privilege, unfortunately the title in the position paper is Contextual Truth, but it's common law qualified privilege, and how that defence applies to publications to a particular ethnic or linguistic community. If you publish something in a language other than English, as I said at the beginning, it's a fair bet that the people who read it will all be members of a particular ethnic, cultural, religious group. As we know, the common law defence of qualified privilege is predicated on there being a reciprocity of duty or interest between the person who publishes defamatory matter and the recipients of the publication. They need to have, the defendant needs to have a reciprocal duty or interest in publishing information about that topic, and the recipients of the publication need to have such an interest in receiving that information. And so a question which has been raised in some cases is, if you write an article in Mandarin and it's read by Chinese people, for instance, is that in and of itself enough to give rise to that relevant reciprocity of duty or interest? Now, in some circumstances, a shared language or cultural background may be an element of a common law qualified privilege defence. I acted in a case a few years ago called Aaron Proprietary Limited and ARIA in the District Court. And that was a case about a defamatory review of a travel agent, which was posted on Facebook. But it was posted in a closed Facebook group called Desi Mums Connect. Desi is an endonym for Indian people. And the defendant, my client, was a mother of Indian background who had used the services of this travel agent to fly to Chennai with her infant daughter. So we argued common law qualified privilege, and we put that argument on the basis that there was a relevant reciprocity of duty and interest in this case, because this was a group for mothers of Indian background, people who would have children and might have reason to travel to India and be relevantly interested in the services of a travel agent, particularly a travel agent who advertised itself as specialising in organising travel between India and Australia. And the thing that she published was about her experience of travelling to India with a child through this travel agent. Judge Aberdeen in the District Court found that these circumstances did give rise to an occasion of qualified privilege at common law. And in relation to the question of language, he said that this forum where the defamatory matter was published was not just a Facebook group, and it wasn't even just a mothers group. He said, some of the mothers in the group, I can infer, may have difficulty in speaking or writing in the English language, and therefore experience some difficulty or disadvantage in participating in the commercial life of society generally. It's not to say that everyone in the group would have that issue, but some of them would. It is in the interests of society, His Honour said, that clubs of this kind develop so that those facing that disadvantage and possibly even marginalisation or isolation can be assisted with the help of others to participate in the life of the community. Now that decision might be read as providing some support for the idea that the common linguistic or cultural background gave rise to an occasion of qualified privilege, but that was only one of the integers in the case. It was of equal or more relevance that this was a group for mothers who might be interested in travelling with children to India through the services of this type of travel agent. Zooming back from my own personal victory, the authorities as a whole don't support the proposition that language or ethnicity in themselves create a relevant community of interest. The leading authority on that subject is Andreevich and Kosovic. It's a decision of the full court of the New South Wales Supreme Court in 1947. The plaintiff and the defendant in that case were both Yugoslavs, and the matter complained of was an article published in Croatian, in a Croatian newspaper, which imputed that the plaintiff had been disloyal to the Yugoslav national liberation movement during the Second World War, and that he was a fascist. Now, it was argued for the defendant that this gave rise to an occasion of qualified privilege, but that argument was rejected. And Chief Justice Jordan, with whom Justice Street agreed, held that what the Yugoslav partisans were doing during the Second World War was merely a matter of general public interest. And as we know, if you publish defamatory matter to the world at large on something which is merely of general public interest, there's no occasion of qualified privilege. It didn't make any difference to this conclusion that the matter happened to be published in Croatian. The Chief Justice said, simply because you might be, he gave the example of a Jewish person who was interested in what was happening in what was then Palestine, or a Chinese person who was interested in the then ongoing war between the nationalists and the communists. Those people have shared interests, but they're merely interests in matters of public interest, and it doesn't matter if you write the article about that thing in Hebrew or Chinese or indeed Croatian. It's not in the interests of society as a whole that people should have liberty to defame each other simply because they happen to come from the same linguistic or ethnic community. The issue arose again in a case called Skalkos and Asaf. The plaintiff in that case was suing over a letter which the defendant had sent to Paul Keating, of all people, when Paul Keating was the Prime Minister. A copy of that letter was translated into Serbian and published in a Serbian newspaper, and it conveyed imputations to the effect that the plaintiff exploited the publishers of ethnic community newspapers for his own financial benefit. Now, the trial judge held that this was an occasion of qualified privilege. That was not challenged when the case went to the Court of Appeal, and the Court of Appeal generally said some nice things about the trial judge's reasoning. But on a reading of the decision as a whole, for the reasons that are explained more fully in the position in the paper, it's not authority for the proposition that there was a relevant interest simply because the matter complained of was published in Serbian to Serbian speakers. Came up again in the Ukrainian case that I referred to, Matika and Goyan. In that case, the argument for qualified privilege was put on the basis that they were all members of the Ukrainian community, talking about the affairs of the Ukrainian community, and it was rejected in that case too. And then the most recent authority I can find is a case in the Court of Appeal from 2011 called Korean Times and Puck. So in that case, the matter complained of was published in a Korean newspaper, and it stated that the plaintiff was being investigated by ICAC on suspicion of making a dodgy donation to a minister. Now, the defendant accepted in that case that this was not the kind of publication which would be qualified privilege if it had been published in an English language newspaper. But they said the position was different because it was published in Korean, due to the fact that many of the readers of the Korean Times may not have had other sources of information about government and political affairs. Those people, so it was said, were likely to be dependent on a Korean language newspaper for their information. And that was a reason why it should be accorded protection. That argument was rejected by the Court of Appeal. Justice Nicholas, with whom Justice Beazley agreed, held that the authorities gave no support to the notion that the non-English language press is in a different position than the English language press. The fact that the readership of non-English language newspapers is limited to those who understand the language in which they are written does not of itself establish the necessary reciprocity of duty and interest. And that's the court's last word on the subject as far as I can see. If qualified privilege were extended to publications in languages other than English, the effect would essentially be to give those publications and members of those communities greater protection than the general English-speaking community. It would not be the same level of protection, but a greater level of protection. The reason why the defendant's argument in the Korean Times case was misconceived, if I can say so, is that it's not that Korean speakers have a greater need for information about government or political affairs which is more deserving of protection. It's simply that their need is different. The effect of the defendant's argument would have been to give them a greater degree of protection. But as I sought to show with the example of the ARIA case, language or culture may be an element of a common law qualified privilege defence. And I should say it may also be relevant to whether there is a apparent interest for the purposes of the statutory defence. Now, to wrap up, I just want to say something briefly about the assessment of damages. Damages in defamation serve two purposes. One is to compensate the plaintiff for damage to his or her reputation, and the other is to compensate the plaintiff for hurt to feelings. And both heads of loss may be affected by the fact that the language the publication is in a language other than English, or directed to a particular community. It may be the case that where matter is published in a community language or a minority language, it will circulate more widely or more quickly because that community, forming a subset of general Australian society, is more tight-knit. That was observed by Justice Brennan in Reader's Digest in Lau, where he said that a jury would be assisted by evidence that the making of the defamatory imputation had an especially adverse effect upon the plaintiff's reputation in the eyes of some group or class in the community. Not to crow on another of my personal cases, but I was involved in a case called Pan and Cheng, which concerned a series of anonymous letters written in Mandarin that circulated within the Chinese community. Those letters didn't go to very many people, but the sort of people that they went to included the ambassador of the People's Republic of China. In assessing damages, Justice Rothman said that even though the publications didn't go to very many people, the fact that they were deliberately sent to influential members of the Chinese community necessarily involves the proposition that the grapevine effect would have been even larger than would ordinarily be the case. It is not conjecture to posit that within a minority group in Australia, scandalous accusations of this kind will circulate to an even greater level than might be the case within the general community. Now that was challenged on appeal, but Justice Simpson, with whom the other members of the court agreed, didn't see any difficulty with that reasoning. Her Honour said that the publication in the Chinese language makes circulation within the Chinese community likely, if not inevitable. Brackets, the grapevine effect. Now these considerations may also be relevant to assessing the plaintiff's hurt feelings. Particular words, as I've already discussed, may have particularly stinging cultural connotations, may be particularly offensive. That was the issue which arose in the Ukrainian case, Matika and Goyard, where evidence was adduced about the fact that the relevant Ukrainian word for witch is particularly nasty in Ukrainian. Now, it's not clear from the reasons of the trial judge, but I think the only basis on which that could have been admitted is that it was relevant to the plaintiff's hurt feelings. So practitioners who are taking instructions from clients in these types of cases should be particularly astute about obtaining instructions on the cultural connotations of particular words in the relevant language and assuring that that evidence is adduced. Now that's what I had to say about this topic, but I'm happy to take questions if anyone has any. Yes?
Yeah, have you found in your experience that the blossoming of social media has increased the number of cases that involve other languages and maybe people in other jurisdictions, for example?
There have been a number of WeChat cases in recent years in the District Court. I don't know that it's necessarily a social media issue. Cases, as we've seen, the cases about foreign language publications in this state go right back to the 40s, probably earlier. And in the 1970s and the 1980s, there were quite a few Greek cases. I think that is because, and I can say this because I understand he's now dead, but the proprietor of the Greek language newspaper in New South Wales was particularly prone to defaming people. And there was quite a large number of cases about Greek language publications in the 70s and 80s. I do think that the development of some social media apps like WeChat, and there's a Korean one called Kakao Talk, I think, or Kakao Talk, maybe. The development of those has given rise to litigation, and we've definitely seen the WeChat cases, but I don't know if it's resulted in a big quantitative change. I mean, in fact, we've probably seen the community newspaper market decline in recent decades. I don't know if there's any evidence for that, but anecdotally, community newspapers like the Greek newspaper, the Italian newspaper were more vibrant in previous decades, and that may be reducing the number of cases that we see about foreign language publications.
I'm intrigued by your suggestion that the parties could have a single expert but underlined words in disputation about which of the varying meanings is to be employed in a particular case. How would there be contest then if there's a single expert about which is the intended meaning in that case? Do you have the expert themselves speaking about those varied meanings, or is it argued what's most appropriate in context?
Well, as I said, I think this has received almost no attention in the cases, as far as I can see. And there are big practical problems with any of the solutions that I proposed. I didn't have in mind so much a single expert. From a procedural point of view, when the plaintiff commences proceedings, he or she has to annex to the statement of claim a translation of the matter complained of. The question is whether the defendant
agrees with that translation or seeks to put it into issue.
Yeah.
Now, if the defendant seeks to put it into issue, one thing they could do is survey competing translation. It is probably the case, if that happened, the court would probably have to have an interim hearing to resolve the translation, if the discrepancies are material. The alternative would be for the defendant to say, I basically agree with your translation, but that particular word, which you've translated as which, for instance, I want to put an asterisk next to that, and I want the court to know that it also means these things, or it carries these particular shades of meaning. But even if you go down that route, I think there's still the practical problem of, at some point the court has to resolve that dispute about, even if the court is told that, say, 3 shades of meaning are possible, the court has to say which one is the preferred meaning. And it's very difficult to see how the court can do that without actually hearing evidence from the translator or competing translators on that issue. That's doctrinally problematic because we have this principle that you don't adduce evidence on the meaning of words. But it's also going to increase costs and the complexity of litigation, which is not desirable for obvious reasons. Anyone else? No? All right. Thank you. Enjoy the bar.